So good afternoon or good morning, depending on where you are, to everybody. I think we are ready to start, like our second webinar of the series on legal avenues to access international protection, hosted by the Italian Academy of Law and Migration. Today, we're very pleased to have three experts who will explain to us the strengths and the criticalities of the resettlement system in Canada, a system which is often considered a model to be inspired by. So for sure, it will be an occasion for us to learn and reflect on the issues that are nowadays affecting also the right of asylum in Italy and in Europe. Since I do not want to take any time away from today's protagonists, I'm going to immediately leave the floor to our first speaker, Professor Francois Crepeau, who will be followed by Adele, Garnier, and Shauna Labman. Well, Professor Crepeau, who we are very happy to have him back at a seminary of the Italian Academy of Law and Migration, and who I'm personally delighted to meet again, mindful of my good memories at McGill University. I don't think that he needs any presentation, but just saying only a fraction of what he has done and he is doing. Professor Crepeau is a full professor at the Faculty of Law at McGill University, member of the Scientific Committee of the Agency for Fundamental Rights of the European Union, chair of the thematic working group Migrants' Rights and Integrations in Host Communities of the World Bank Group, former director of the McGill Center for Human Rights and Legal Pluralism, and former United Nations Special Rapporteur on the Human Rights of Migrants. And today, he will open our meeting with an introduction on the right of asylum in Canada. So, Professor, the stage is yours, and thank you very much.
Thank you, Luca. Thank you very much for inviting me and for organizing this. So I've been asked to talk about asylum in Canada, so the right of asylum. So three elements, three parts. One about a bit of a history of asylum, then how the Immigration and Refugee Board of Canada functions quickly, so you see what kind of administrative apparatus was put in place, and finally the Save Third Country Agreement with the Roxham Road debacle, I would say. So first, asylum. Asylum, as you all know, is a state power. It's the power to welcome and protect anyone they want for any reason they decide is important to them. So that's what Canada has done, like all other countries. From early on, if we count the loyalists as refugees from the United States, which they were not because they were British subjects going to British territory, so they were not really refugees, but they found refuge in Canada, between 60 and 100,000 of them after 1776. End of 19th century up till World War I, many people who would qualify today as refugees came as immigrants. Jews, Doukhobors, Poles of all kinds. We had really a very important influx of people who would be refugees today as immigrants. In the 20th century, in the 20s and 30s, lots of Ukrainians came, very often as immigrants again. During World War II, we refused many refugees, including many Jews. Most Jews who tried to come to Canada were pushed back, and there's this famous, or infamous rather, sentence by a Canadian civil servant, "None is too many," which has resonated over the decades until today. During the Cold War, we welcomed many people from beyond the Iron Curtain. For example, we welcomed in 1956, 40,000 Hungarians. Now they came not as asylum seekers, but as resettled refugees, most of them from Austria and other countries. Chileans, we were less keen on them because they were, communists, but we still welcomed 13,000 of them, just to give you ideas of what happened. And then in the 70s and 80s, many Central Americans came. Guatemalans, Salvadorans in particular, and they often came with the help of Canadian diplomats who helped them take planes to Canada. In 1976, there were in Canada 600 asylum claims. Half of them were in Gander, Newfoundland. That's north of Newfoundland. It's a 12,000 inhabitant community, which at the time was very famous because it was still an international airport, a very important international airport, and half those 600 asylum seekers came out of Soviet Union because Gander was still a refueling station for the Moscow-Havana flight. And so that's where those people came in 1976. 10 years later, from 600, we went to 60,000 asylum seekers. So what happened during those 10 years? And these are the crucial years for asylum in most countries in the global north. First of all, the oil shocks of 1973 and 1979 created high inflation, high unemployment, high interest rates. And politicians found no better way to assuage the fears of their population than to close the borders and say that they will not welcome immigrants in order to not increase unemployment, which was, which is an equation that has been denounced by all economists and demographers. Migrants actually do not, except in very small pockets of the labor market, migrants do not displace citizens in most cases. So Canada adopted a closed border policy, just like all other global north countries, and pointed fingers at immigrants as being responsible for certainly unemployment and other social ills. And we've been stuck with that decision ever since. This was also enabled by technological advances. The reason why we had so few asylum seekers in 76 was that most people who needed protection could come as immigrants or without a visa as a visitor, and then if they found jobs, they could get quite easily a work permit and a residence permit in most global north states. This was the current affairs, how affairs functioned in the 50s, 60s, and the early part of the 70s. From the end of the 70s, early 80s, it was a lot more difficult, and people started coming by themselves, also thanks to transcontinental flights, but also thanks to television, which allowed them to visualize what life was away from home, thanks to telecommunication, the easy way that you had to communicate with family members through telephone and then cell phone. So all of these helped people move by themselves. And certainly after the global north closed their borders, many people who came as immigrants had now to ask for asylum. And suddenly the numbers increased everywhere. And actually the term asylum seeker appears in the media in 1982 and 1983. Before that, there were no asylum seekers, there were refugees. The people who arrived at Gander and jumped off the plane from Moscow were refugees. They were not asylum seekers, even though in today's terms, we would call them refugees. This was reinforced for sure after 9/11. The US pressured Canada to adopt the same kind of border policies that the US was adopting. Canada transferred lots of data of, for example, airline passengers to the US without much guarantees. And I'm told, maybe Shauna and Adele could confirm that, I don't know, but when Canada decided to welcome the refugees, the Syrian refugees in 2015, 2016, it seems that there was a phone call from Washington saying, okay, you can bring in Syrians, we recognize that you can do that, but please only take families, don't take single males. And that's a rumor I heard. I don't know if it's true, but it sounds true. It sounds very true. Anyway, that's a picture of how Canada closed progressively its borders to asylum seekers. And Canada has integrity officers around the world to prevent people taking planes or boats to Canada, like most countries have, trying to prevent people who might be asking for asylum in Canada. Now, this meant that in the early 80s, the system to manage asylum claims, which was a very simple administrative office in Ottawa, was totally overwhelmed. You know, going from 600 claims to 60,000 claims is simply, you know, you can't predict that. And so we had you know, a number of difficulties. One thing that the Canadian government tried to do was to paper process asylum claims, but there was quickly a crafty lawyer who went to the courts and eventually to the Supreme Court, and the Supreme Court ended deciding in April 1985 that since the right to life, security, and freedom was at stake, people needed to be heard in person. And so you needed a hearing. You could not do a paper process. And ever since, we've had hearings in person for asylum seekers. But that created chaos and, you know, backlogs in the system. We had a report by a well-known expert, Rabbi Plout, almost at the same time as the Singh decision of 1985, and the Immigration and Refugee Board of Canada was created in 1989. This is an independent administrative tribunal dedicated to all immigration matters and refugee matters. It has 4 divisions: the Refugee Protection Division, the Refugee Appeal Division, the Immigration Division, and the Immigration Appeal Division. So these 4 divisions treat different aspects of the immigration policy of Canada, including refugees. The Refugee Appeal Division was promised in 1989, but never created until 2012. It took, you know, 23, 24 years before it was created, but it was finally created, and it created an internal appeal because many decisions of the IRB were overturned by the federal court, but it was a cumbersome process. The decision makers inside the IRB are independent decision makers. Some of them are civil servants, some of them are administrative judges appointed by cabinet, but they're all independent decision makers. It used to be that the appointments were patronage appointments, i.e. the party in power in Ottawa would appoint its friends, and very often people who had lost elections or, you know, friends of the party. It has changed over the years. It has become, you know, it's waxing and waning, but it has become a much more professional body in recent years. Many, just to give you an example, many of my students have been appointed. So it must be a better process because they are certainly more trained in immigration matters than was the case 20, 30 years ago. It's a huge tribunal. Like in most countries, this administrative tribunal is the biggest administrative tribunal of the land in number of cases. In the IRB, currently there are, and I've counted, over 550 decision makers, either civil servants or administrative judges, which is a huge number as compared to other tribunals. The process is what you would expect. An asylum claim, an asylum seeker who arrives at the border will be received by someone from the border agency, Canadian Border Services Agency, CBSA. That border agent will ask questions. The answers will be recorded. That record of answers will be available later in the process, which is an issue, but is standard process. The asylum claim is then filed with the Refugee Protection Division, and there is a hearing. The hearings are all recorded, sound recorded. So we have the recording and we have the transcript available if need be for appeal purposes, but also for research purposes when we have access to them. And that's an important point because I've done research with those recordings, and you get from the recording things that you don't get from the transcript. And the transcript itself, which is not available in all countries that I know of, gives you also information about what has been said. But what the recording gives you is the tone of the conversation. And when a board member, for example, gets angry at the answers of the asylum seeker, there's an issue. And this is something that you can't detect from the transcript. So these recordings are actually very important. Interpreters are provided by the Immigration and Refugee Board, and they're all professional interpreters in most languages of the refugees. You have sometimes issues about, if the interpreter is not exactly of the same ethnic group of the asylum seeker, you might have, political issues that might interfere, but most of the interpreters are very professional, and they're told to professionally translate, i.e., the exact words of both the board member and the asylum seeker. So that's a good point of the system. However, one not good point of the system is legal aid. Legal aid was not provided with the system at the time and was left to provinces to create alongside their legal aid schemes. And so one province provides quite good legal aid in terms of hours of work. Ontario, Quebec, a few hours, but insufficient in most cases, because when you have asylum seekers who don't speak the language, you need an interpreter. And if it's a traumatic experience, well, you need to gain their trust, and that takes time. And if you have 2, 3, 4 hours paid with the legal aid, you don't have the time to gain that trust. So, and some provinces don't have legal aid for asylum claims at all. So that's an issue. That's not a good point of the system. And the vast majority of asylum seekers are actually represented at the IRB, and they need to be represented because it's a complex process, and very often decision will hinge on a few words, a few sentences, a few details. The decisions are taken at the IRB, at the Refugee Protection Division level, within 2 years, mostly. Currently, COVID has not helped with the delays. At the RAD level, so the Refugee Appeal Division, it's 9 to 12 months from what I can see. I'm not sure about the most recent months, but maybe Adele and Shauna will be more precise on this. And the reversal of the initial decision by the Refugee Protection Division is quite frequent at the Refugee Appeal Division. It's 25%, between 20 and 30% of decisions have been reversed in recent years, which is quite high in terms of an appeal body. The claims, the asylum claims in Canada for the past, let's say 23 years since 2000 varied considerably from year to year. In 2013, there were 10,000. In 2019, there were 70,000. And last year in 2022, 50,000. On average, probably around between 40 and 45,000 over the years for the past quarter century. The acceptance rates is quite high. In 2021, it was 70%, but it has gone down. On average, over again the past quarter century, probably around 45 to 50%, 1 out of 2. Grosso modo. It's quite high as compared to many other countries. We have to understand that the definition used in Canada includes the Refugee Convention definition, but also the definition of the Convention Against Torture, people fearing torture or cruel, inhuman, and degrading treatment or punishment. And that means that these are the two categories of people that are subjected to the principle of non-refoulement. And so that was put together. That's one thing. And two, it's difficult to get to Canada. You have to come to Canada. You have to, go through either 3 oceans, Atlantic, Pacific, Arctic, or the US. It's quite difficult. And the integrity offices we have abroad prevent most people coming by plane. So that's this, grosso modo, the mechanism for treating asylum claims. Now, Canada has negotiated, like most European countries and many other countries around the world, a safe third country agreement with the United States. That was done in 2002, took effect in the end of 2004, if I remember well. And that meant, and that said, that asylum claims could not be, well, if an asylum claim was made at a border post, at the border between Canada and the US, either country could send the person immediately back to the other country without studying the claim, with a few exceptions. If you had family members in the country, for example, that was an exception, but most of the claims would be not studied and would be returned. The explanation for this is that both countries are democratic countries that actually have good asylum systems, and therefore there's no need to entertain a refugee claim from the US in Canada, since the US is a friendly country with a democratic system. That's the explanation. Now, the treatment of asylum seekers and refugees generally in the US has been historically often very different from that of Canada on many issues. This has meant that you could not go, if you wanted to go to Canada from the US to ask for asylum, you could not go to a border post. So what did you do? Well, you went outside a border post. And just to remind you, the land border with the US, between Canada and the US, is 9,000 kilometer long. That's a lot of space for you to go through if you want to. There's no way we can build a fence that long. And that created what we have called the Roxham Road issue. Roxham Road in Quebec is a small, used to be a small dirt road that crossed the border. Before 9/11, it was unguarded and it went through. You know, there were plenty of those little roads that went through the border. When I was a kid, my parents had a chalet near the border, and I used to go to the US on my bicycle without encountering anyone, no border guard, nothing. You know, it just went through because the dirt road would just go through. And so Roxham Road was suddenly used. And after arresting a number of asylum seekers, and since they had set foot in Canada, you could not reject them. It was not part of the Safe Third Country Agreement, and you had to, take in their asylum claim. And so it became an industry, i.e. many people came through Roxham Road over the years, and many people arrived. There was no smuggling involved at all. It was all in the open. People arrived by taxi, by buses from different parts of the US, arrived at that little roundabout just before the ditch that marked the border and connected, that prevented connection with Roxham Road anymore. But on the other side, you had, border agents, Canadian border agents waiting for you. And as you approached with your suitcase and your children as an asylum seeker, they would tell you across the ditch, stop there, don't move. If you cross, you're going to be arrested, etc. And most asylum seekers said, yes, that's what I want. And they crossed and they were arrested, but they were not rejected. They had their asylum claim was entered and processed in the Canadian system. This was inconvenient for the authorities. Political parties were denouncing the fact that the border was unguarded, that these people were coming, we didn't know who they were. This was becoming a political embarrassment for the government. And on the 24th of March of 2023, so 3 months ago, the Safe Third Country Agreement was extended to the whole border between the US and Canada, not simply at border posts. So now if you arrive at Roxham Road, you will be pushed back into the US because they can, thanks to the extended Safe Third Country Agreement. On top of this, on the 16th of June, so 10 days, last week, the Supreme Court, after a lengthy process, declared that the Safe Third Country Agreement was constitutional, that it was not against the the constitutional protection of the right to life, liberty, and freedom, that this was an issue, this issue of immigration control was an issue to be negotiated by states between themselves, and that both countries had mechanisms to protect people who were, in danger, and therefore it was free to them to negotiate that kind of agreement. That kind of agreement was quite normal in international relations. They left one issue pending and sent it back to the federal court, which is whether the treatment of women refugees between Canada and the US is sufficiently different to create gender discrimination, in which case Article 15, which is the right to equality and the prohibition of discrimination, could render this part of the Safe Third Country Agreement unconstitutional, but this will be decided in a few years, probably going back up to the Supreme Court, but we won't. Now, this decision to extend the Safe Third Country Agreement is a political, electoral decision to save the government the embarrassment of having to defend its border policies during the next electoral cycle, especially now that we have a minority government. They didn't want to have to defend that. It's a political decision. It has nothing to do with proper border management, because Roxham Road was an excellently managed process. People came without smuggling, without underground criminal gangs or rings helping them, without the cost to them of paying those smugglers, and without the risk of going through the border through smuggling rings. And they said, yes, I want to enter, and I enter, and they were all immediately registered. We knew who they were. We knew we could run their names through, databases, security databases, etc. It was extremely well managed. And suddenly we are in a situation where we've opened an underground market for smuggling rings. Because if the government believes, and I know the government, doesn't believe that, but if the government believes that this is going to stop asylum seekers, we know they're dead wrong. But we know they don't believe that. They know very well that people will go through for two reasons, which are both as important as the other. One is that most of those people actually need to come. We've had an acceptance rate of 70% last year, I remind you. So these people need to come. And second, we have huge underground labor markets to employ them in Canada. And we have hundreds of thousands, if not of millions, of Canadian employers ready to employ them. No one dies of hunger in Canada. Everyone works at exploitative, wages and labor conditions in many cases, but everyone works. So if you have a need for, employing at cutthroat wages, and you have a need to come in and you put a barrier between the two, you just create an underground labor market. If the government does not facilitate mobility between those two needs, other people will, and this is going to happen, and this is going to happen in dangerous conditions. And we already have had deaths at the border since the Safe Third Country Agreement was extended, and we had some in the past year as well. So frozen in the forest or drowned in lakes, etc. So the situation in Canada is quite different from that of Europe. We're farther from zones of conflicts or human rights violations, but we still have quite a very border control attitude to asylum claimants. We have a different attitude towards refugees whom we pick and choose abroad, and that's for Adele and Shauna to explain. Thank you.
Thank you very much, Professor Crepeau. I think that we can leave all the questions to the end after the three speeches. So now is the time for Professor Adele Garnier. who is now, I just give like a short introduction also for her. Naturally, she's now a professor at Laval University, but having studied and worked in several universities and research centers on both sides of the oceans. And I have to say, like, not just the Atlantic Ocean, but also I think like other oceans, since she worked in Europe, in Canada, and also in Australia. She's a political scientist, so she's helping us to fulfill the promise of interdisciplinarity of our meetings. And she's the author of several contributions on resettlement, migrants integration, and labor market participation of refugees, such as the 2018 book on refugee resettlement, power, politics, and humanitarian governance. Without further ado, Adele, the floor is yours, and I think you can share your presentation.
Thank you so much for the introduction, Luca, and also thank you for the great presentation by Professor Crepeau. This is great to follow on this. So I will share a few slides. I am not a lawyer, indeed, and so let's see if it works. Share screen. Okay. Can you see the slide? Fantastic. I've just put it in. Okay, so I'm just going to zoom out again to the global context, which was mentioned at the end, to just come back to a few numbers. So I work in geography and in demography also, so there's going to be quite a few numbers, and if it's too much, I'll go fast. But this is just to show we have more than almost 110 forcibly displaced people in the world at the moment, and it has increased greatly in the last few years, as you all know. But the availability of durable solutions for refugees has not increased. So there is really a sharp increase in the demand for durable solutions. And here you have a graph on two of the durable solutions. The first was mentioned by Professor Crepeau, which is local integration in the first country of asylum, following an asylum claim or refugee arrival. And the two others being safe return to the country of origin and refugee resettlement. So departure from a first country of asylum to a third country who is willing to admit these persons. So the thing with refugee resettlement is it's discretionary. A lot more, I mean, there is law involved. It's not a legal abyss like it's called sometimes, but there is less law involved than the refugee status determination and asylum procedure. Because of this increase in the need, of course, and the problem that we have is the decline in the availability of resettlement slots. So as you can see, this has greatly fluctuated. That is the global context here. There was sort of a renaissance in the 2000s, but it has really declined until 2019. And I will come, of course, to one of the main causes of this and how Canada is different from that. But it has increased a bit since the end of COVID again, but we are still far from having enough slots, and there is less than 1% of the refugees at the UNHCR, United Nations Agency for Refugees, who are considered in need of resettlement, who find a slot to be resettled. So this is again another chart showing you the global resettlement needs versus admissions with statistics. Again, we are almost at 1.5 million people in need of refugee resettlement for UNHCR. These are the most vulnerable refugees who are in first countries of asylum, who fear for their life, for the security of their families, who have particular vulnerabilities. These people are considered to be in need of resettlement in more or less long term. And as you could see, the highest year that we had before COVID, and we're not back yet, is 126,000 slots globally. And that declined in 2020 to 20,000, almost to 23,000 slots because of COVID, but even the years before it had declined. What is also very concerning in this is the decline in the number of countries which resettle. So when we published the book in 2018, as you can see, there was more than 30 countries who are doing refugee resettlement. And in 2021, it was down to 23. So a number of countries who were engaged in resettlement have stopped doing it or have limited their resettlement. So in Europe, it's, for instance, Denmark and Belgium who have a stop and go attitude towards resettlement. And of course, the problem that we have with the numbers in the last few years has been the presidency of Donald Trump in the United States, who greatly diminished availability of resettlement slot. Against resettlement is a discretionary policy, so you can quite quickly cut the numbers of resettled refugees in countries. Now, Canada has been different in the last few years because, of course, there has been a decision under the prime ministership of Justin Trudeau since 2015 to significantly increase the number of resettlement slots as compared to the previous administration of the prime minister of Stephen Harper, the Conservative government before. There was a lot of civil society pressure to increase resettlement from 2015. So I'll talk about this a little bit later, but this is just to show that this has meant really that in the last few years, and that will change again with the new American president of the new, Joe Biden, because resettlement is increasing again. But for these years, Canada has been a leader in refugee resettlement globally. This is due to the decline in the US, but still, even if we don't discount the US, Canada has traditionally been well placed as the second biggest destination for resettled refugees, and then Australia the third, and then Scandinavian countries. However, and this is really important to mention, and Professor Crepeau alluded to this, the main way of coming to Canada, if you want to go there, is to be an immigrant. And not a humanitarian immigrant or a forced migrant, but as an immigrant for economic purpose. And so meaning that even as we have increased refugee resettlement and generally humanitarian admission in Canada is a minority of immigration to Canada. So here historically, you can see how the dark blue line is economic migration, has dominated immigration in Canada for a long time. And family migration is also higher, that's the light blue one, compared to refugee immigration, which is the small one. I return now to the evolution of refugee resettlement. So as Professor Crepeau said, one key legal moment in the history of immigration policy and law in Canada is 1976 Immigration Act. That created the category that we have broadly for refugee resettlement now to Canada. And since that will be the second act that is very important, and I'm just giving you this as key points to remember, is the Immigration and Refugee Protection Act, the IRPA, adopted in 2001, that came into force in 2002. So these are the two big legal framework that we have, and the 2002 one is the one in which we work, and the regulations happen now. As you can see, refugee resettlement, and it's been said before, has fluctuated. So Professor Crepeau mentioned large European resettlement from Eastern Europe after the Second World War. And after that, and in the context of the new act, that happened, and then the act happened in 1976, is Indo-Chinese refugee resettlement. In the 1970s and 80s, that's where you see very much an increase of refugee resettlement, and then Latin American, Central American refugee resettlement as well. Kosovar refugee resettlement in the 90s. As you can see, it was extremely stable in the 80s and 90s. Now, let's not forget that Canada's population has increased greatly during that time, so it has diminished the proportion of refugee resettlement. There were 24 million Canadians in 1980. We just passed 40 million. So meaning this sharp increase that we see had to be put in the general context of being a minority amongst immigrants and a smaller proportion of the Canadian population, even though it has increased. Of course, now, what is really interesting to see is the different category that we have. So we can see them on the graph here. Okay, so Canada has roughly said, but that's the broadest one, 3 resettlement categories since 2013. Government, and before that it was 2. So I'm just mentioning the 2 first that we see in green here and in blue. So it's government assisted refugee resettlement and privately sponsored refugee resettlement, GARs and PSRs. For the last 10 years, since 2013, we've had a third category, BVORs, so blended visa office referred refugee resettlement. And I'll come to this in a minute. But first, what you can see on this graph is that GAR resettlement has fluctuated less over the years than privately sponsored refugee resettlement, which has increased at times. So as you can see in the 80s, it increased massively in the context of less Canadian population, and it was very important. And now it has also increased more than GAR refugee resettlement under the Trudeau government. We also see this BVOR category that I will talk about in a minute, has had its sort of a peak in 2016 and has never really increased since. It has remained in very marginal category. Another thing to know that was also mentioned a bit by Professor Crepeau is there is one province that does things a little bit differently in Canada, and it's the province of Quebec. So Quebec has its own autonomy over the selection of permanent residents, and that includes resettled refugees. And Quebec has decided not to have this BVOR program. So that's why in Quebec, we only have 2 categories. I won't talk too much about the province, but this is just to say that there are 2 sort of systems on the Canadian territory. The other provinces have the same model of admission. And asylum is the federal competency that applies across the country. Is that everything? So I'm now turning to the categories that you can see. So this is from a piece that is an interesting short read if you're interested by Ian van Haren on private sponsorship with the models. And of course, I refer you to the great work of Shauna Labman, who's done more on refugee resettlement. This is a table that can show you the differences. So especially since IRP, so since this Migration and Refugee Protection Act of 2002, there has been a stronger focus in Canada on resettling refugees through the government-assisted program of vulnerable refugees. And this is sort of consistent with what the UNHCR has been doing. So there has been sort of an alignment of priorities between Canada wanted and the civil society as well, pushing to resettle more vulnerable refugees through government-assisted resettlement. And so in terms of the profile of the people who come to GAR resettlement, they are more vulnerable, larger families, people with disabilities, people who have spent years in refugee camps, illiterate people, for instance. This is that. So how it happens really is not that the resettled person of the resettlement candidate for GARs or for any category of resettlement can say, I would like to come to Canada. This is done by other authorities. And this is important. You can't name yourself to be resettled to Canada. The personal agency of the person who wants to come is very different from an asylum claimant. So in the case of the GARs, it's UNHCR in Canada. Generally, there can also be delegated agencies from UNHCR, but to be simple, we can say UNHCR makes a proposition, and then Canada decides to resettle this person. Gets in touch with then the persons. Sometimes the person have really no idea how the whole process works. And then in Canada, I mean, there is a training, you know, cultural orientation, but sometimes people really come and are quite, I don't have any prior connection to Canada, because really the focus is vulnerability. The other 2 programs, it's a mix. So it's sort of what has been referred sometimes as private-public partnerships, and is also promoted on the world stage by the Trudeau government since 2015, especially PSR, privately sponsored refugees. What is very specific with this is that sponsors can name the refugee that they want to have resettled. So the person cannot be advocate for themselves, it's their sponsors. And Canada has different types of sponsors, either small groups of 5, or larger groups of sponsors. And they have a number of, so the larger groups have sort of more flexibility. They are more institutionally anchored with working with the Canadian government, and they have more flexibility. Also different is that the first year of arrival to Canada, the sponsors support financially the privately sponsored refugees, and they enter before the whole sponsorship happens into an agreement with the Canadian government that they are going to provide money for the persons, and then they are supposed to also provide orientation and assistance to privately sponsored refugees. However, this is left to the sponsors, and so there have been a great heterogeneity of support offered to privately sponsored refugees. In the case of the BVOR, so this little yellow thing you saw before, the government chooses the refugee, but the sponsors choose to get involved. So it's a mix of responsibilities. One thing that is important is that we are still in the migration law framework of Canada, meaning on paper, in the law and in the regulation, these permanent residents who have permanent resident status when they come must demonstrate the ability to establish to Canada. So this is sort of what in Europe is often referred to as integration potential. That's what the law and the regulation say. Say you have a family connection in Canada, you know the language, you have a job offer, you have education. However, in the IRPA, this act, since then, there are clear provisions to immigration officer to greater weigh the need and of the refugees and the vulnerability as compared to ability to establish. So the more vulnerable the person, the less significant the criteria of ability to establish, and it's the same in Quebec regulations for law. So I will just finish my part, perhaps with just mentioning to you the differences. So I can actually close my slide here. If I make a difference to how it works in Europe, sort of, the difference really, and that's not the case of all European countries, but it's really that people already come with permanent residency. They don't have to reapply to asylum when they come, and permanent residency is permanent. So it's not a 5-year visa or a thing like this that often refugees get. All sorts of refugees also after an asylum claim in Europe. There is also less, and that's interesting, in the resettlement discourse, less association with migration management concerns. So Europe has this thing now where they're thinking about granting resettlement agreements to countries where there is safe return, or they are going to work, but if they send back the migrant that shouldn't be there. With refugee resettlement, as opposed to asylum, Canada has not done this like that. You have to give some nuance, because in private sponsorship, what happens now is that it's mostly privately sponsored refugees sponsoring their family. So there is a migration path. It's a sort of unofficial family reunification program for refugees for many, but there isn't this thing to say, we are going to measure resettlement against asylum slots. It's not that clear. It's not like in Europe, and especially not like in Australia. So I can come back to this at the end if you want. This fact that this global resettlement discourse is very different from other resettling countries, and especially in Europe. And I will now give the word to Shauna, who is going to focus more on the tension that we have now between privately sponsored refugees and government-assisted resettlement. Thank you very much.
Adele, thank you very much. So as you say, basically you have done the introduction, so is Shauna time. I just also say like that she's right now a professor of human rights in global college at the University of Winniepeg, if I'm right, I hope so. And she also had an extensive field experience being a lawyer and having previously worked for the United Nations High Commissioner for Refugees in New Delhi, the Canadian Embassy in Beijing, the Law Commission of Canada in Ottawa, the Worker Compensation Board of British Columbia, etc., etc. She's author and editor of several contributions on resettlement, such as the 2019 book on Crossing Law's Border, Canada's Refugee Resettlement Program. Shauna, thank you again for your presentation and for being here, and the microphone is yours.
Thank you. And I think I'm now sharing my screen. Can you all see it? Wonderful. Thank you for having me and inviting me. So I'm just going to move this down a bit to make sure it's clear. Adele started by saying that there's less law involved in resettlement and that it's a discretionary act. And the title of this event today is Legal Avenues and talking about resettlement. And so I went back to a quote that I use fairly significantly in my book, Crossing Law's Border, from 2019, from Canada's Immigration Department, which was at the time Citizenship and Immigration Canada. That's now the Immigration, Refugee and Citizenship Canada. And this is a statement on their resettlement programs from March 2011. And the points in red are just the points that I'm going to read, because what's so interesting about this presentation of resettlement by the Canadian government is, in fact, its focus on law. So they say, these refugees wait patiently for the chance to immigrate to Canada or other countries legally. And by that, waiting patiently to immigrate, they're referring to resettlement as opposed to what Francois talked about is asylum. They say Canada's programs for refugees to resettle here legally, being again that entrance with the permanent resident visa that comes with resettlement, as opposed to coming any way you can and claiming asylum, which, as Francois talked about, has become more difficult with the Safe Third Country Agreement. They say the program for refugees to resettle here legally went from being one of the most generous in the world to being even more generous. They like to present themselves well. And in the final paragraphs, they say all of these individuals who immigrated to Canada through our resettlement programs waited patiently in the queue. So this idea that there's a queue, which Adele has just pointed out there is not, between asylum and resettlement, for the chance to come to Canada legally. They followed the rules. So again, this sort of distinction and presentation of the difference between asylum claims and resettlement that's rather problematic. The government will stand up for these refugees' rights to be processed in a fair and orderly fashion, consistent with our laws and values. Now, these were statements by a conservative government in 2011, but when Francois also talked about the pressures of the current minority government and the tensions of an upcoming election, you see this pressure at play currently and continuing in different ways. So yesterday was World Refugee Day, and we have there a statement from the Prime Minister of Canada on World Refugee Day. And what was quite telling about this statement again yesterday is that on World Refugee Day, the only things that the Prime Minister of Canada spoke about were Canada's resettlement efforts and Canada's efforts, so efforts towards Afghans, as well as Canada's response to working with LGBTQ plus refugees. So a very humanitarian presentation, but again, through Rainbow Railroad, through resettlement actions. And they mention, I believe they mention in this also efforts towards Ukrainians, possibly. Yep, Canada will also continue to welcome Ukrainians fleeing Russia's brutal invasion. Well, of course, the Ukrainian reference is not to a resettlement program. It's to a temporary visa that does not offer permanent protection, but offers a visitor's visa for a temporary amount of time. And so those Ukrainians are still in Canada with likely some access to permanent protection through different routes, but no clarity on what that permanent protection is. So it is not, in fact, a refugee protection route. What the statement ends with is learn how to apply for refugee status from within Canada. Find out how to come to Canada as a refugee, sponsor a refugee, or find refugee services in Canada. So what this doesn't talk about in any way is what Francois talked about, is that right to asylum, those limitations on that access to asylum, the fact that the week before the Supreme Court of Canada had made a decision on that, and a few months previously, having known secretly for a year prior to this that they had negotiated this expansion of the Safe Third Country Agreement with the United States, it was released that by midnight, that rule would change and the border crossing would be more permanently sealed, which is, I think, quite arguably why we saw a sudden increased deaths as a result of that expansion quite quickly after that was acknowledged. What you see at the bottom of the statement too is find out how to come to Canada as a refugee or sponsor a refugee. And even if we go back to 2011, the statement from the government at that time really focuses on the private sponsorship program. So the things that I think are interesting when we look at Canada's model is we have a legal obligation to refugees through the 1951 Convention, through our commitments in international law brought into our domestic law for asylum, which we increasingly build obstacles against. We responded to the fact that Canada is in fact far from refugee flows by creating a resettlement program that in many ways preceded our commitment to asylum and the establishment of the Immigration and Refugee Board. But increasingly, we have resettlement as a response to presenting our humanitarian efforts as opposed to asylum. We sort of hide from what we're doing on the border because that's less humanitarian and a little messy. We look at refugee resettlement, but increasingly the refugee resettlement that we're looking at is not the government resettlement, is not the government assisted refugee program, but attention to that private sponsorship program. And what we've seen over the years, well, there's been a massive increase in Canada's resettlement program over the last few years. Numerically, the significant increases, an increase of over 200% has happened in the private refugee sponsorship program, not in the government program. And so that is an interesting dynamic. Adele and I have an upcoming book chapter called A Necessary Reassertion of Government-Assisted Resettlement, because we're concerned with this dynamic between the two. What the Canadian government does is it puts out an immigration levels plan. And so these are the projected targets with low and high range commitments moving forward from 2023 to 2025. What you have in the top category here are the protected persons in Canada and dependents abroad, and this is the asylum stream. And then you see the government-assisted refugees, the privately sponsored refugees, and the blended visa office referred refugees that Adele mentioned. Now, because we're coming out of the pandemic, the government and privately sponsored are relatively similar, although you still see a significant higher number in the privately sponsored commitments than you do in government resettlement. When I started researching these areas in the early 2000s, between 2000 and 2010, what you had traditionally was between 8,000 and 10,000 government assisted refugees per year and only 2,000 to 2,500 privately sponsored refugees a year. So the PSR program has gone like this, and the government program has gone slightly up. When you see this moving forward, because we're coming out of the pandemic, the government numbers are actually going downwards. So by 2025, those numbers dip almost another 10,000, going from 23,500 to a target of about 15,000. whereas the privately sponsored refugees continue to rise. So what we have in Canada is the shifting nature of how we are bringing people to Canada. We're sealing the border increasingly, and we're increasing the numbers we welcome, but we're shifting who and how we welcome people. And the demand for sponsorship is moving up. And I'd say since 2015, Canada became quite popular in the moment of a new shiny prime minister in 2015 with Prime Minister Trudeau. But there was a significant surge as a result in the interest in private sponsorship. And there's a couple of reasons for this. Sponsors want the numbers. There's something called an echo effect with refugee sponsorship, that no matter whether refugees come to Canada by way of asylum, by government resettlement, or by other immigration routes, the only way Canadians can intersect and bring people here, name the people they want to help, is through the private sponsorship program. So you have a continuing and growing demand because the parameters of the regulations go beyond the refugee definition. That capacity to name people does expand to an extended family reunification model that is both very valuable and a little complicated, because that protection focus, that vulnerability focus, the refugees that come to Canada by way of private sponsorship are of course always very much in need in one way or another, but they're not necessarily the prioritized referrals that UNHCR would be sending through the government program, nor are they necessarily even within that massive and growing and overwhelmingly increasing number of refugees recognized by UNHCR. They might be completely outside of that convention refugee recognition to begin with. The cost, it's simply more cost efficient for the government to rely on private sponsors than completely do government resettlement. And this is because sponsors, Canadians, permanent residents in Canada, are coming up and offering to put their own money, their own volunteer time, their own supports into settling these people. And so when you look at it numerically, it's a complicated question, because on one side, you can bring more people because there are more people engaged in the support of it. There's also a settlement question involved in this. And so the settlement is two ways. One thing is government resettlement is located only in the limited places where those settlement services are established by the government of Canada. We call these RAP providers, resettlement assistance programs, and they are in core major cities across the country. There's only about a dozen of them. In contrast, sponsorship can be across Canada. It can be in small rural communities, it can be in northern communities, it can be in big cities or small cities, because individuals get to name and bring people to their communities. So you have a much bigger scope of expanse. But tied to that settlement is what is sort of an integration settlement issue. So the interesting thing about resettlement is there's a moment in time when your decision making is based on protection. These are people who need protection, and so we are bringing them to our country. But then, as Adele referenced, the successful establishment criteria, private sponsorship itself takes on responsibility to support these individuals for a 12-month period until they reach self-sustainability. There's a question of how these people succeed when they get to Canada, because we don't want them to just sort of get here and fail. And so that there's an integration question. But when you're picking people from different needs, whether you're the highest priority needs that UNHCR refers, whether you've been in a protracted refugee situation for 20 years or born into a refugee situation, or have the means and connections that lead you to know friends and family here in Canada, shifts your integration, shifts your settlement support. And so as some studies are trying to look at the integration and settlement realities and successes of arrived refugees through resettlement, between comparisons between GARs and BVOR and PSRs, privately sponsored, so government or privately sponsored, sometimes in the short term, you see the privately sponsored refugees being more successful in getting employment and buying houses and finding supports for themselves. And yet the arrival circumstances of those groups look really different. And that nuance is a harder thing to suss out in the exploration. And then to take this, and I'm going to wrap up quickly because I know we want to get to the question time. The challenge here, and we're coming up to an election here in Canada, and the politics is always, there's the law, but then there's the politics overwhelming all of it. So the Conservative Party of Canada, which is our party in opposition, has been quite frank in their proposals and their recovery plans that they propose. This is from a prior election, that their proposal and plan is to move entirely to a private sponsorship model away from the government model. And their justification for that is the slightly complicated integration and settlement studies that show in the short term privately sponsored refugees have better integration potential than government. But that takes aside and loses sight of the ever important protection question. And that protection question becomes even more relevant when we're thinking about the closure of the border and the lack of access to asylum. And so if resettlement is our response, if the Canadian government, going back here, presents resettlement as our way to respond to refugees on World Refugee Day and forward, we have to think really carefully about what that means if we're shifting to a program that is focused not on protection, but on integration. And so then to take it back more globally, we have, when the Canadian government in 2011 was really sort of bumping it on our heads that the legal immigration route is resettlement, the language we've moved to now in the current world system is complementary pathways, other movements and ways to bring people in. And what the Global Compact's roadmap said about this is these additional safe and legal avenues for refugees are important to increase access to protection. And of course they are. If we are expanding access, if we're finding alternative routes. Canada has a new program called the Economic Mobility Pilot Program, which brings refugees in through our economic pathways because they're actually skilled migrants as well. Just the fact that they're a refugee doesn't mean that they don't have the education and skills to work as IT specialists or engineers in our country. But what the Global Compact says on this is they should continue to be used alongside and in addition to resettlement as a tool of solidarity and responsibility sharing. And this question of additionality becomes so central to all our questions about refugee protection. So going back to asylum, if asylum is our legal route, is our legal pathway recognized in international law, recognized in Canada and domestic law for refugee protection, then resettlement should be additional to that. And private sponsorship, at least framed by private sponsors in Canada, has always been presented through this sort of principle of additionality. The private sponsorship is in addition to the government commitment, not in replacement of it. And then I think as we look at these complementary pathways as these additional routes that are coming, again, what it kind of highlights, what it risks is to ensure that these routes continue to be additional rather than carving out of or taking from other commitments that states make to refugee protection. So I'll leave it there for now.
Shauna, thank you so much for your like really good presentation. I really enjoyed it, as all the other presentation. So right now I'm just opening the floor to the question time. If someone has some question, they can just open the microphone. Otherwise, I break the ice because I've got like a bunch of questions that pop on my mind. Well, like more than a few questions in reality. And well, I will start. And I will ask, probably everybody can answer to me. So, well, like feel free, one of you, just like to try to answer. Well, like one is one curiosity, since I read a newspaper a few days ago about like the fact that United States is sort of implementing an application, so like a digital instrument in order to like let migrants, like let asylum seekers to like let's say upload the application before getting to the border. And that's also a mechanism that should involve other countries other than the United States, and also Canada is involved. So like, I would like to have any information about this sort of like integration of new technologies in like this, refugee law system. And secondly, I would just like to ask if during the entire private refugee resettlement system, is there any sort of public control in way of due process, control of respect of due process between during the selection of the beneficiaries of the programs, but also, for example, the adequate level of services provided to people, to the refugees who arrived in Canada by private sponsor? Because here right now in Italy, with the human corridors, we sort of have this kind of issue because they're just given to the private sponsor, and basically there's no control coming from the public part. It's sort of we have no responsibility on these refugees. You bring it in and it's up to the private sponsor, and basically that could also affect the dynamic of the entrance and also quality of the integration mechanism of these refugees. Thank you.
Luca, I'm not quite sure what you're talking about in terms of the new program introduced in the United States. So I don't know if Francois or Adele know about it. Okay, so I'll let Francois, do you want to start on that? And then I can sort of speak to the mechanisms of oversight, and I'm sure Adele can as well.
Yep, I mean, just a few words, because we don't know how it's going to pan out. But what the Biden administration has introduced is an app which any person outside the US can use to apply for an interview. That goes along with the decision by the Biden administration to not accept any asylum application from people who have entered irregularly the territory of the United States. Now, what I've read, and it's, it remains to be seen whether it's going to be like that, is that the administration is preparing for going up to 1,000 interviews per day. If they work Monday to Friday, that could be up to 250,000 interviews per year, which is significant. And if people really are allowed to enter the US to go for their interview, and then decision being taken, I mean, it is changing the pattern at the border. The opposition parties cannot say that the border is not controlled and that it's a free-for-all, etc. It changes the narrative. And in that sense, it might be very smart. If it's another way to say no to 95% of the asylum seekers, it's not going to work. People will not, after a few months of this, the people are going to stop using it and they're going to go with coyotes again. But it could be, if it's managed well, it could be a new way of shaping a narrative at the border and taking control of what is said about asylum seekers. We'll have to see.
Thank you very much, Professor.
It's interesting too, one of the things that Professor Crepeau didn't mention when he was talking about the expansions to the Safe Third Country Agreement is that now in Canada, what an exception to it is that if you manage to get into the country and not be discovered for 2 weeks, you can still make a claim. So on the Canadian side of things, what we've actually created is a system that begs for more human smuggling and surreptitious entries and hiding for a number of weeks. What I've heard is people are booking a hotel room for one night to prove their entry into the city, into the province, into the country, and then hiding. And so the shifting dynamic between Canada and the US and these movements, I'm not sure if this app will be successful in that. In terms of the private sponsorship program, we've got over almost 50 years of this program happening at this point. And one of the really interesting things about that is when you talk to the people who were involved in the 1970s at the start of it, the simplicity of the applications, the simplicities of the forms, which made it accessible for people. What's happened now, and I've done private sponsorships there, even I've written 2 books on it, and I can't figure out the forms. It's a very, very complicated system to put in the application to sponsor a refugee. And a lot of that application is proving financial capacity and a plan for settlement support. Part of it is also ensuring the refugee or named person to sponsor meets the regulation definitions. And sometimes sponsorship applications, when vetted at that point, are rejected, either because of incomplete answers for the financial preparedness to sponsor the family, or because the individual to be sponsored doesn't meet the definitions and parameters of it. Over the years, those questions of oversight of the sponsorship program have increased. There's actually surprisingly very few narratives of failed or complicated sponsorships. They do exist. And sometimes I worry that we're over attentive to the celebratory stories and not as able to bring out some of the more complicated stories. But what the government response has been on that is to create sort of oversight provisions which require more reporting from sponsors. And yet this oversight falls only into the financial. And so it still does not pay appropriate attention to the settlement of the refugees themselves, but to the financial distribution of funds. And what's a consequence of this is a lot of sponsors are saying the reporting and mechanisms of oversight are so heavy on them that it's hard to stay in the sponsorship game. So you've had sponsors who sponsored refugees for years and years and years who are now saying we as a church group, we as an organization can no longer sustain this level of reporting. So there's a really complicated tension that Canada's surprisingly new to, given the history of our sponsorship commitments, in terms of the balance between the need to have oversight and supervision of the program, as opposed to making the program too weighty on individuals who are doing this as a volunteer action to actually keep it going. And that sustainability question becomes quite complicated. There's also a number of sponsorship groups who've reported in interview research I've done that they've met GARs from the same region or community as the private sponsorships they've done, who they don't think the government program is doing appropriate support for those people. And so there was a Yazidi sponsorship here in Winniepeg, where I live, where they resettled a number of Yazidi refugees through the private sponsorship program, and then they stopped their private sponsorship in order to bring in all the government assisted refugees and provide them with greater support. So there's it really touches on a real tension here too. Adele, I don't know if there's more you want to add on that.
Thanks. Just 2 points very briefly. And I think one is a real concern for all of us, which is basically technology is used to depoliticize immigration control. So instead of using the law, it's technology that is used, and it's a huge thing in Canada when immigration control is a highly politicized thing. And so it's really using technology and saying we're modernizing systems. In Canada, this is very big in all the big like tourist visa, temporary migration. They're training artificial intelligence to seed out the application that they don't want any others and say it's a machine who has done this. And I'm very worried about this trend, but I hadn't heard about what Francois talked about, and I thought it was very interesting. On a private sponsorship, briefly, this is even worse in Quebec. So meaning the administrative burden is considerable here, to the point where some of the sponsorship slots for specific streams are not even met because they can't find enough sponsors in the localities where there should be sponsors according to the provincial government. So this is a real issue. At the same time, settlement, and Shauna mentioned this, is an immigrant settlement framework in Canada. We want immigrants to succeed, and refugees are just a small group within the settlement agencies that are helping. And the problem is when there is not enough money from the settlement agencies to do this, sometimes they start blaming the refugees as non-integrable, which is a real issue. So I wouldn't say that control is a problem, but resources is certainly an issue at the moment.
Thank you very much to everybody. Federico Orso, which is a research fellow at Università della Tuscia, as a question. So Federico, please.
Yeah, thank you. First of all, let me thank you all for your interesting presentations, and obviously many thanks to you, Luca, and to Adima for the organization. So I have something to ask to Professor Crepeau. I hope he would excuse me for the terrible pronunciation of the surname. He briefly talked about the IRB, the Immigration and Refugee Board of Canada, which he said is the special administrative tribunal responsible for resolving immigration and refugee matters. He underlined in particular, at least 2 or 3 times, that this tribunal is independent. So I have 2 questions about it. First, is this tribunal part of the Canadian judiciary system or not? And second, if not, so if this tribunal is not part of the judiciary system, how does the Canadian law assure its independence? For instance, its independence from government or parliament. And I have also a question for Professor Garnier. At some point of your presentation, you talked about economic migrants, stressing the circumstance that they are bigger in number than the other types of migrants. If I'm not wrong, in Italy, this expression, the expression economic migrants, is not generally accepted. Italy researchers, in fact, tend to say that migrants always migrate for a combination of push factors, and that even in those cases in which the economic reason is the main push factor, behind it, there are always a number of other reasons related, for example, to wars, political crisis, desertification, climate change, and so on. So here is my question: is this felt the same in Canada, or this is, or the expression economic migrants is broadly accepted in your country? Thank you.
Here. So about the independence, is it part of the judiciary? Now, we are in a British system, so categories are not as clear than in civil law countries, okay? So we have a tradition of independent decision makers in the administration, which, you know, is subject to influence, and certainly with the kind of patronage appointments that we had certainly at the beginning of the IRB and at different times throughout its history, makes it difficult to talk about independence. I remember the anecdote of one of those independent board members who had the picture of the prime minister in his office. So that doesn't, you know, look like independence to me much. But we still have that tradition of independent decision makers in different parts of the administration. They're not part of the judiciary, those independent decision makers. They make their decisions independently from the hierarchy, but in that independence is generally respected in technical matters. That independence is generally respected. What is different here in the IRB is that you have both systems. You have at ground level, the Refugee Protection Division, the Immigration Division. You have civil servants who are independent decision makers. At appeal level, Refugee Appeal Division, Immigration Appeal Division, you have people who are not appointed in the civil service mechanism. You are appointed by what is called the government and council, the cabinet and council, and that is the government and council is the government. So you have an appointment which is that of an administrative judge. Problem at the IRB is that this appointment can be for 2 years, for 4 years, for 7 years, depending on who decides what. In recent years, it's been longer terms, but it means that some of those judges have been in reappointment mode, you know, for a number of, they're appointed for 2 years. So starting at the beginning of year 2, you know, they try to make sure that they will be reappointed. That's a problem for independence. If you're not appointed for a fixed term, if you're subject to reappointment and you want to show that you're worthy of reappointment, well, independence is diminished. So it's a mix. The answer is a mixed bag, I would say.
Thank you very much for your question. Okay. So yes, I would say, and I'm saying this as an immigrant myself because I'm French. Canadian immigration policy is the discourse is highly utilitarian. It's basically immigrants are contributing to the prosperity of this country, and it's a highly popular discourse. The exceptionality of Canada is for the last 30 years, the popularity of immigration is very high. Bringing more migrants as really being a target of this particular government now, and except in Quebec, but even there, actually, on the whole, it's super popular. It's even super popular to bring refugees through orderly and legal pathways. As we said, asylum seekers is another issue. But this view that migrants contribute to prosperity, everyone is an immigrant here apart from indigenous people. It's this discourse of settler countries. You've got the same in Australia, very much, and I guess in the US as well. Now, what I mentioned with economic migration, that was a policy category. But what is interesting in Canada, though, in comparison to, I would say, Italy, France, and a couple of other places in Europe, though not everywhere, we've got better relationship with our governments as experts. We work with them, and there is a tendency from some experts to take policy categories as face value. I mean, I wouldn't say this, but I would say it's far more consensual to see this like that, even though because you have so many immigrants here, you recognize that this is just a category and that immigrants have family members who are sick. I came as a family, I came as a family immigrant. We are sort of, the Quebec government is very hostile to us, but that's okay. I'm making a contribution. So we recognize the difference as researchers, but certainly this vision of immigration is useful. It's super popular here. Like it's a completely accepted discourse. And if asylum seekers are useful, good on them. This is the way of seeing them at the moment, is part of the workforce. This is very different from Europe.
Thank you very much, Adele. Well, I promise 1 hour and a half for the seminar. Oh, we have Daniela. So I was ready to have another question, but so Daniela will be the last. Daniela, please.
Thank you very much, Luca. And first of all, let me apologize for the delay. I did my best to come on time, but I didn't make it. Unfortunately, this session has been recorded. But I want to, give a big thank to all the speakers. And connecting to the last questions, I was wondering what you all think about the proposal of the European Commission of a European model of community sponsorship, and this idea which was put forward in the European Agenda on Integration and Inclusion, and the new pact of scaling up national schemes and national models of private sponsorship which have been developed in European countries. And what do you think about the options for policy transfer between European member states? Thank you very much. And again, apologies for the delay.
I can start on this. So I think as a starting point, the hugest benefit of private sponsorship to Canada, and I think this ties back to what Adele was just saying in terms of how Canada approaches refugees as being valuable, is that private sponsorship means that Canadians know refugees, that they have a hand in working with them. They learn to see them as their friends, their families, their neighbors. And so that outsider foreign fear of a refugee that can be created is lessened for at least 1% of the population in Canada through the private sponsorship program. So private sponsors become in themselves some of the greatest advocates across this country for all refugee protection, because they have that commitment to the refugees they meet. And because in working to bring those refugees over, they face immense obstacles and time delays and hear the stories of persecution and suffering that really compel them to act more. So by bringing in sponsorship models in Europe, what you will likely see is a leveling or increase of support possibly for refugee protection. On the other side of it, I think the challenge is that Canada developed a resettlement program and a private sponsorship program because what a geographer in Canada, Jennifer Heinemann, calls cold ocean geography. We are surrounded by cold oceans. The United States is our only border. It's really, really hard for asylum seekers to get here. They do, and they increasingly have over the last 40 years compared to when our resettlement programs developed in the 70s and early 80s. But it's hard for people to come here. We've had, I think the number is about 10,000 boat arrivals on the shores of Canada over the history of our country. So the realities that Canada's program operates in look so different than the realities you sit in Europe, where the flows of migrants, the concern and the red flag I always have for all this is the rationale an increase, or is the rationale being used in the same way that the Canadian government's even using it now to justify closures and increased obstacles to asylum? And so I think that's the tension for advocates, that there is real value in these programs, but not if it's completely at the cost of access to asylum.
Thank you, Shauna. So if no one else, well, may
Adele?
one last question, super fast.
Yeah.
Thank you so much. I'm just wondering, what's the timing of the proceeding? Like for both PSR or like the government-assisted refugee mechanism? It's like in terms of months, days, years, because it will affect just like drastically the efficiency of the system. I don't want to insist with Shauna, but I don't know.
I can answer that, but it's years, very long years. I mean, it can take up to, in some sponsorship cases, I mean, we can go to up to 8 to 10 years. It's extremely long. It's very difficult. It's to the point where provinces like Quebec is trying sort of a lottery and trying to even reduce the caseload of people who can apply for sponsorship. So it is a very big issue. And we do know, and this is what I was showing at the beginning, the demand is never going to be met by enough slots. And the problem has, even with the increase in recent years, it has just increased over time, because other countries also are not picking up, you know, there's no burden sharing or responsibility sharing much. So I would say it's actually getting longer over time.
I think there's also differentials. So traditionally it can be years of waiting, which makes it really hard for sponsors to plan for the arrival and settlement. We also have an urgent protection program. So there's been famous cases, Rahaf Mohammed, who was a Saudi teen who was tweeting from her hotel room in Thailand a couple of years ago, was brought over to Canada in a number of days when there was sort of a political agenda. The Syrian resettlement to Canada as well. The Prime Minister made a commitment to bring over 25,000 government-assisted Syrian refugees and brought visa officers out of retirement to process those claims more quickly. So it's a choice on how many visa officers are processing applications, what proportion of their time is going to it, which really can shift whether these applications go through swiftly or the tendency is for them to take years.
Thank you so much, Shauna. Thank you so much, Adele. Thank you so much, Professor Crepeau. It was like a wonderful meeting for us. We learned a lot. And so thank you again. And well, I hope to see you soon, maybe next year, maybe in a few months, for other occasion of interesting speech together. So thank you again. And have a nice day, you in Canada, and then have a nice evening here in Italy.
Thank you very much for the invitation.
Bye-bye.
Bye.
Thank you. Bye.